Hey everyone, welcome back, and if you are new here, welcome. Before we start, thank you. This channel is growing because of you. Every view, every comment, every subscribe, I do not take that for granted. Now, what I am about to show you is something almost nobody is talking about. Let's get into it. On February 20th, 2026, the Supreme Court of the United States did something that almost nobody expected. It struck down the biggest trade policy of the Trump presidency. In a 6-3 decision, the court ruled that the International Emergency Economic Powers Act, known as IEEPA, does not give the president the authority to impose tariffs, period. That single ruling invalidated virtually every major tariff imposed since February 2025. The reciprocal tariffs, the fentanyl tariffs on Mexico and Canada, the emergency duties on China that reached as high as 145%. All of it declared illegal. And the number that matters most is this. The federal government collected approximately $134 billion in IEEPA tariffs. Some estimates put the total as high as $175 billion. That money now has to go back. And the fight over how and when that happens is already getting ugly. Here's the full timeline of what happened, what the government did next, and what it means for the economy. The case that reached the Supreme Court started with small businesses. A toy company called Learning Resources and a wine importer called VOS Selections challenged the tariffs in court. They argued that IEEPA, a law passed in 1977 to deal with national emergencies, was never meant to give the president unlimited power to tax imports. The law says the president can regulate importation. The plaintiffs said, regulate does not mean tax. The case moved through the Court of International Trade, then the Federal Circuit Court of Appeals. Both courts agreed the tariffs exceeded presidential authority. The Trump administration appealed to the Supreme Court. Oral arguments happened in late 2025, and on February 20th, 2026, the court issued its decision. 6 justices, including the Chief Justice, agreed. EPA does not authorize tariffs. The president overstepped his legal authority. Justice Kavanaugh wrote a dissent, and he made one point that turned out to be prophetic. He said the decision would generate serious practical consequences, specifically the question of refunds. He called the refund process likely to be a mess, and he was right. Here's the problem. The Supreme Court struck down the tariffs, but it said nothing about refunds. Not a single word about how the government should return the money. It sent the case back to the lower courts to figure it out, specifically to the Court of International Trade in New York, a little-known federal court that normally handles disputes about things like anti-dumping measures and import classifications. This court has 8 active judges. It typically gets around 250 new cases a year. In the 2 weeks since the Supreme Court ruling, it has received approximately 2,000. Companies like FedEx, Costco, Revlon, and L'Oreal have filed lawsuits demanding refunds. But they are just the tip of the iceberg. The tariffs that were ruled illegal were levied on more than 300,000 importers. Most of those importers have not filed anything yet. They are waiting to see what process the court creates. But the clock is ticking. Under customs rules, importers typically have 180 days after an entry is finalized to contest duties paid. On Friday, February 28th, just 8 days after the Supreme Court ruling, the Trump administration asked the Federal Circuit to wait. They wanted 90 days before sending the case to the trade court. They said the delay would give Congress time to come up with a legislative solution. The court said no. On Monday, March 2nd, the Federal Circuit issued a one-page order. It rejected the government's request for a delay and immediately sent the case back to the Court of International Trade. That was a major loss for the administration. They wanted 4 months to figure out their next move. They got 0 days. And then on Wednesday, March 4th, the trade court itself made the next move. Judge Richard Eaton, a senior judge who was put in charge of all tariff refund cases, issued an order. He ruled that companies are legally entitled to refunds. He ordered Customs and Border Protection to finalize paperwork on imported goods without charging the now illegal tariffs. For goods that had already been processed with those charges, he ordered officials to redo the paperwork. This does not mean companies will get checks tomorrow, but it is the first concrete step in the refund process. The legal foundation has been laid. Importers are entitled to their money back. Trade lawyers expect the government to appeal, and Trump himself has said this could lead to 5 years of litigation. His exact words, "I guess it has to get litigated for the next 2 years." He later said 5. But the courts are moving faster than the administration wants. Every request for delay has been denied. Every motion to slow down has been rejected. Now, here is where it gets complicated. The administration did not sit still after the Supreme Court ruling. Within hours, Trump signed 3 executive actions. First, he terminated all IEEPA tariffs. That was required by the court's decision. Second, he imposed a brand new tariff under a completely different law, Section 122 of the Trade Act of 1974. This law allows the president to impose tariffs of up to 15% for a maximum of 150 days to address what the statute calls fundamental international payments problems. The initial rate was set at 10% on all imports from all countries, effective February 24th. Trump announced on Truth Social the next day that he intended to raise it to 15%, the legal maximum. This is a fundamentally different legal tool than IEEPA. It has hard limits, 15% maximum, 150 days maximum. It expires on July 24th, 2026, unless Congress votes to extend it. Compare that to IEEPA tariffs, which had no rate cap and no time limit. China was paying 145%. Under Section 122, everyone pays the same flat rate. Third, Trump continued the suspension of duty-free treatment for low-value shipments. The de minimis exemption that previously allowed packages worth $800 or less to enter without duties. That stays suspended. So the tariff landscape did not go to zero. It shifted to a different legal framework with much tighter constraints. And the administration has already signaled what comes next. They are launching new investigations under Section 301 of the Trade Act, which allows targeted tariffs on countries engaged in unfair trade practices. And they are expanding Section 232 investigations, which allow tariffs based on national security concerns. The strategy is clear. Use Section 122 as a bridge for 150 days, while building cases under 301 and 232 that can sustain higher, longer-lasting tariffs. But there's a massive financial question hanging over all of this. Where does the refund money come from? One trade lawyer put it bluntly. It is not like there is over $100 billion sitting in a room somewhere to just cut checks. The tariff revenue was spent. It went into the Treasury and was used for government operations. Refunding it means either cutting spending elsewhere, borrowing more, or raising new revenue. Some analysts believe this is exactly why the administration moved so quickly to impose the Section 122 replacement tariff. Not just for trade policy, but because they need the revenue to fund refunds. The Treasury problem is real. TD Securities estimates that actual refund payments could take 12 to 18 months to roll out, even under the best circumstances. And the customs agency system was not designed for mass refunds at this scale. One trade lawyer said the system was built for individual errors, not for returning tens of billions of dollars to hundreds of thousands of importers simultaneously. Meanwhile, the political pressure is building from every direction. The governor of Illinois sent a letter demanding a refund on behalf of the state's 5 million households, claiming the tariffs cost each household $1,700, totaling $8.7 billion for the state alone. Nevada's state treasurer submitted a formal payment request to the federal government for $2.1 billion. And a coalition of small businesses that originally filed the case is demanding that the refund process be simple and low cost, not something that requires every small importer to hire an expensive trade lawyer. For the average American consumer, the most important question is whether lower tariffs will mean lower prices. The short answer, it helps, but do not expect a dramatic drop. The IEEPA tariffs are gone, but Section 122 tariffs are now in place at 10 to 15% on most goods. Section 232 tariffs on steel and aluminum remain at 25 to 50%. Section 301 tariffs on Chinese goods remain at rates up to 100% on some categories. The trade-weighted average U.S. tariff rate before the Supreme Court ruling was about 15.3%. After the ruling, plus the Section 122 replacement, it is about 13.2%. That is a reduction. But it is not a return to pre-tariff levels. The overall tariff structure is still historically elevated. And the refunds themselves, even when they arrive, go to importers, not directly to consumers. Whether companies pass those savings along depends on competitive pressure and individual business decisions. Some companies have already indicated they will lower prices. Others have said the refunds will go toward covering losses they absorbed during the tariff period. Now, what does this mean going forward? The Supreme Court's ruling was narrow in one important sense. It only said that IEEPA cannot be used for tariffs. It did not say the president cannot impose tariffs at all. Section 232, Section 301, Section 122, and several other statutes still give the president significant tariff authority, just with more procedural requirements and legal constraints. The administration has already made clear that tariff policy is not going away. The tools are just changing. But the ruling did establish an important principle. Presidential power has limits. Emergency powers laws cannot be stretched to cover anything the president wants, and the courts are willing to enforce those limits, even against a sitting president's signature economic policy. Justice Kavanaugh identified 5 alternative tariff authorities in his dissent. The administration is already pursuing at least 3 of them. The tariff era is not over. It is entering a new phase with different legal rules. The refund fight will continue for months or years. The trade court is moving aggressively. The administration is fighting for delay. And somewhere in between, Over 300,000 importers are waiting to find out when they get their money back. $134 billion. Collected under authority the Supreme Court says never existed. The largest government refund obligation in American history, and it is just getting started. Now, this channel will continue tracking the story as it develops, the refund process, the new tariff investigations, and any price impacts that hit consumers. When the next ruling comes down, the update will be here. But most people will not see that update. They are not subscribed. They will find out after the fact, when prices shift and the headlines have already moved on. If you learned something from this video that you did not know before, hit subscribe. It is free. It takes 1 second. And it means the next time something changes, you hear about it while there is still time to act. See you in the next one.